The Supreme Court's recent decision on parental consent for abortion, a detailed overview. In a pivotal development, the Supreme Court chose not to review a Montana statute that mandates individuals under the age of 18 to obtain parental approval before having an abortion, thereby upholding a ruling by the state court that invalidated the law. Enacted back in 2013, Montana's legislation prohibited doctors from performing an abortion on a patient under 18 without notarized consent from a parent. The state's highest court determined this law clashed with the Montana state constitution, which offers more extensive protections for abortion rights compared to the federal constitution. Interestingly, the Supreme Court didn't disclose its reasoning behind this decision. However, conservative justices Samuel Alito and Clarence Thomas issued a brief statement suggesting that the technical issues with the case made it unsuitable for addressing the fundamental question about such laws. They emphasized that this rejection shouldn't be interpreted as a dismissal of the arguments presented. Montana's representatives argued before the Supreme Court in January that parents inherently have authority over decisions pertaining to their child's health care. They contended that parents are presumed to act in the best interest of their child, and that the state has no right to intervene in the private family sphere unless there is evidence questioning the parent's fitness. Planned Parenthood, on the other hand, contested the law, focusing primarily on its conflict with the state constitution. They argued that Montana's stance seemed to treat parental rights as the ultimate and final aspect, ignoring other potentially relevant rights and considerations. Under the Montana law, doctors who perform an abortion without parental consent would face both fines and prison time. The law mandates that a physician secure notarized approval from a parent or guardian for those under 18 seeking an abortion. Additionally, it provides an option for the minor to bypass this requirement by demonstrating to a court that they possess the maturity and understanding to make the decision independently. Looking back, the Supreme Court faced a similar matter in the 1970s after its landmark ruling in Roe v. Wade in 1973. In the case of Planned Parenthood of Central Missouri v. Danforth, the court ruled against similar consent requirements, basing its decision partly on the constitutional right to abortion established in Roe. Similarly, in 1979, the court invalidated a Massachusetts law that lacked the judicial bypass provision for minors. Montana argued that the law at the Supreme Court's decision 3 years ago to overturn Roe in Dobbs v. Jackson Women's Health Organization strengthened the state's justification by asserting that similar abortion rights are recognized in Montana's constitution. In their appeal, Montana maintained that the state's ruling disregarded parental rights, challenging the notion that parents should be informed and involved in their child's crucial medical decisions, including the choice about abortion. The state court reasoned that, like adults, minors too possess a fundamental right to privacy. This right importantly encompasses autonomy over reproductive choices and the freedom to make essential healthcare decisions in collaboration with a chosen healthcare provider, free from unwarranted governmental interference. So, what do you think about the principle of parental rights in healthcare decisions for minors? Do you believe that parents should always be involved, or should there be more room for minors to decide about their own healthcare? Let us know your thoughts in the comments.